The next case is case number 19CA0008-M, in re JJ. Both parties are represented by counsel, so each party will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Just let me know how much time you need. I'll try to keep track. Also, we have the clock on the TV screen there too, so you can keep track of your time. The arguments are recorded. They are posted on the court's YouTube channel. So we ask that you not only keep your voice up and stay close to the podium, but also because we record the arguments, we ask that you refrain from using the names of children and or victims during the presentation. We've read the briefs. We're ready to proceed if you are.
Morning, Honors.
Morning.
Eric Hall on behalf of the appellant Kelly Howell Morris. I would like to reserve 5 minutes of my argument for the remaining of Your Honors.
Very good. I'll keep track of it. Also keep track of Walter.
Thank you, Your Honors. Case involves termination of parental rights of the appellant. In this case, termination of parental rights with her son, JJ. Your Honor, first assignment of the trial court erred when it denied the appellant's counsel's request for continuance, repeated request for continuances. Trial court, at the first day of the hearing, trial court informed the court, our trial counsel informed the court that the appellant was not present, was having difficulty obtaining transportation to the hearing. The trial judge denied that continuance. On day 2, trial counsel renewed a request for continuance, stating like the appellant was not here, was continuing to have difficulties. Again, the trial court denied that continuance. Your Honors, I argue that was an abuse of discretion. This hearing was so critical and important. It involves a very important right, the right of a parent to raise their child, that not postponing, I understand the court schedule, but to not postpone this type of a hearing when the outcome, especially the outcome that took place, is so harmful and denies a parent a right to forever see their child, raise their child. The trial court should have continued that case.
Counsel, is there a difference between my client can't make it because my client can't get a ride with no further information, and my client can't make it because my client's in the hospital?
Well, you certainly, there are differences, Your Honor. I mean, and I would agree with that. In this case, I believe the court, counsel for both sides was aware of some of the difficulties that the appellant was having. Difficulties with substance abuse, health issues, difficulties with work, obtaining employment, and difficulties in maintaining safe and stable housing. Under those circumstances, the court was aware of the circumstances of this appellant, and under those circumstances, should have granted a continuance. The appellee in their brief states, well, we didn't demonstrate what type of prejudice that suffered. The fact that they weren't there, well, it's rather obvious. They weren't able to offer any testimony as to the efforts that they were making as far as obtaining the goals of the case plan. Their goal and desire of reunification with their child, which that, counsel can cross-examine witnesses and present witnesses, but without the appellant mother being there, the court really couldn't get a feel or any kind of a picture of how much the appellant desired reunification and how she was struggling and trying to follow a lot of these issues in the case plan, which she was having. Look, without question, she was having difficulty, but she could have explained what difficulty she was having and what steps she was taking to overcome those. So she had a drug problem. And as this court's aware, it's a struggle. She was struggling with that, but she was doing things. She was making progress on her case plan. She was addressing the issues of the drug addiction and some of the mental health issues. But without her being there, the court really couldn't get a very good picture of what those efforts were and how much she desired the reunification. Certainly, I can't tell you 100%, and no attorney can, but had she been testified, the outcome could have been different in the case. I think that's without question. And I can't tell you that the trial court would have changed its decision in this case, but certainly, given that opportunity, she would have had a much better chance of getting a different outcome than she got in this case, Your Honors.
Couple questions. Was there a reason given for her failure to appear for day 2 of the trial?
I believe that it was still continued transportation problems, and
Is there a history of her not appearing for court in this case?
there was a history of her not appearing for various appointments and some other things that had to do with some of the case plan objectives and things she had to do in the case plan. And that was because of 2 reasons, okay? One was transportation, and 2 was also she was struggling with a problem, with an addiction problem. And everybody was aware of that, Your Honor. Happily was aware of that, and the court was aware of it too, through numerous filings and other hearings that involved both appellant mother and the father in this case.
I'm assuming somebody testified concerning her compliance with the reunification plan.
Absolutely.
Was there an opportunity to question or cross-examine those witnesses on her behalf about any treatment she was receiving for her addiction issues, about housing, current housing situation?
That did come out in the hearing, Your Honor, that there was cross-examination. Her trial counsel was able to get that information on the record, and that goes to my second assignment of error, Your Honors, that the trial court erred. And it uses this, well, first of all, the decision to terminate the parental rights was against the manifest weight and sufficiency of evidence, and also was an abuse of discretion in this matter. The appellant was committed to the case plan. Granted, she was having difficulties, and she was struggling to meet some of the objectives of the plan, but she was engaged in each objective. She was engaged to a degree in trying to obtain it. At no time during the pendency of this case did she indicate that she wasn't trying to get reunification with the child. At no time. And that makes this case different than some other cases where the parent is not sure whether they want reunification, or at first they do, then they don't. So the court's really not sure. This case there was never a time where she indicated that she did not want reunification. Working toward that. She's always been, when sober, she was always appropriate with her child. At no time during the pendency of the case was there ever an issue of her causing or a concern of causing physical injury to the child. It wasn't a concern. And that happens in a lot of cases where there is an issue of physical harm, domestic violence to a child, or a concern of physical harm. Not in this case, Your Honors. She had the appropriate reciprocal mother-child relationship with the child. Okay. And that's something that she doesn't have now. She had, despite her struggles with obtaining housing, she was able to obtain, and this is in the transcript in the hearing, she was able to obtain a stable and safe housing. And that was one of the requirements of the case plan.
Did she have that housing at the time of the hearing?
Your Honor, I'm not sure. She wasn't there to testify as to her situation, her current situation at that time. And that would have been very important for the judge to hear this, in this case.
Would the caseworker have testified as to her contacts with the mother and where she was living at the time?
There's some testimony, Your Honor, that she had lost housing. There's also testimony that she obtained stable and safe housing. So in my view, review of the transcript, it wasn't really clear to me that at the time of the hearing what her situation would have been. It would have been easily discernible had she been there and been able to testify. And finally, there's no question that she was engaged in drug and treatment counseling. Okay. That she recognized she had a problem, and she was taking steps to address those problems. And as this court's aware, drug addiction and along with mental health issues are not, they're complicated and they're not easy to simply just address. They take time and they take effort, and there's success and there's failure and then there's success again. And it's an ongoing process, and it continues throughout. Once somebody has an addiction problem, it usually continues throughout their whole life.
Was she also receiving mental health treatment?
Yes, she
And
was.
counseling? She was involved in that?
She was involved in both, because she part of the problem she had was with her relationship with the child's JD's father, who, and this is not a part of the record, but has since deceased.
I don't want to hear it, it's not part of the record. We're limited to that.
I understand, Your Honor. It's tragic, situation. Your Honor, do you have any further questions?
GAL testifying in this, and so what was the recommendation of the guardian ad litem?
GAL never had any contact with the appellant, and that was,
Why was that?
my understanding, based on reading the transcript, that he was unable to contact her for some reason. I don't understand why that happened, because if her trial counsel was able to contact her, have communication, I don't understand why the GAL wouldn't be able to establish communication through her counsel or even to the court. She would have to have been able to be contacted somehow in order for the case to go forward as it did and be on a case plan. Appellee had her contact information. Trial counsel had her contact information. For some reason, I don't understand why the GAL wasn't able to do that, Your Honor.
All right, that leaves you with 4 minutes, 49 seconds for rebuttal.
Thank you.
Thank you. Counsel, you have 15 minutes.
May it please the court, my name is Amanda Castellanovo and I represent Medina County Job and Family Services. A complaint in this matter was filed on September 5th of 2017 after the execution of voluntary agreement of custodies due to father's overdose in the home with mother and child present and mother's relapse on marijuana and cocaine. The child was adjudicated dependent and the agency received temporary custody of the child. At the time of the permanent custody hearing, the social worker had worked and testified to working with mother for approximately 3 consecutive years due to an older sibling. As to mother's first assignment of error, the trial court did not abuse its discretion by denying the motion to continue. The determination of granting a continuance is in the broad discretion of the trial court, and there are certain factors that should be considered by the trial court when ruling on such a motion, such as
What you just said, it struck me when I read your brief, because of the 3 consecutive years because of the other sibling, I know you mentioned in your brief. Did any of that, for the good or the bad, and apparently the caseworker in this case represented more bad than good as to those times, did any of that prior to this child, the complaint on this child, did it matter? Could it have been considered by the trial court?
I believe it was considered by the trial court. There was, primarily the testimony came in under the substance abuse, under how the agency had continued to work with mother, and how at the time of the filing of this complaint, it was marijuana and cocaine. By the time of the permanent custody hearing, it was daily use of heroin. I don't think there was many details provided, but I believe that the social worker did testify that she had worked with mother for 3 years. And I think that went to just the weight of her testimony about knowing mother, about knowing the family. But yes, she did testify just foundational about that, Your Honor. In this case, I believe the court did consider the motion for continuance and denied it properly. In this case, a motion for permanent custody was filed in July of 2018 and was scheduled out for at least 2 months later. The trial court acknowledged on the record that this had been scheduled for quite some time. This wasn't something scheduled days before. Therefore, mother had plenty of notice to obtain proper transportation to the hearing. Additionally, mother's counsel appeared late himself for the hearing. He walked in 30 minutes late after it started promptly at 9 a.m. and opening statements had already been made. He acknowledged on the record that he had received a text message from mother at 9:14, 14 minutes after the court had already begun the proceedings, indicating that she had a flat tire. But he also requested a late start. But mother continued to fail. She failed to show up after lunch, and she failed to show up on day 2 of the trial. However, on day 2 of the trial, mother's counsel acknowledged that he had not heard from her that morning. He had heard from her the evening prior, but did not know her circumstances that morning on day 2. And there is history in this case of mother's failure to show. She had failed to participate in the majority of the case. She attended one agency review that's held every 90 days in the agency setting, and she had not attended a court hearing since February of 2018, and that came in specifically through the guardian ad litem.
How many of those would you have missed?
Review hearings happen within Medina County Court every 90 days, Your Honor, promptly. In this case, the agency did not present testimony that mom did not have a desire for reunification. But there was testimony provided by a social worker, mother's therapist from Ohio Guidestone about that reunification progress and her case plan objectives. Mother's counsel fully participated in the 2-day hearing. He cross-examined all witnesses. He was making objections on mother's behalf. Evidence would not have been presented any differently for mother. Moving on to mother's second assignment of error, mother acknowledges in her brief that the agency may have met its burden under 2151-414B1A, the should not, cannot factor, but that the agency failed to prove by clear and convincing evidence that permanent custody was in the best interest of the child. The first factor to consider, that must be considered, is the interaction and relationship. There was testimony that this child was with the foster family since just a week old and continued into that placement until the permanent custody trial. The child's half-sibling is in the legal custody of the foster parents, and that also occurred through an agency case. There was testimony about the relationship between the half-sibling and JJ, that they had a strong bond, that the older sibling would teach him how to talk, would help feed him, would look out for JJ, and JJ was always looking for him, and that they were always playing together. Because of this, the trial court found that the relationship between the foster family and the older child was the most significant relationship.
Can I ask you a question about that too? You said that the older child is in legal custody of the foster parents. So does that mean that the mother still has continuing visitation rights with that child?
That is correct, Your Honor.
So, and this is that child's half-brother?
That is correct, Your Honor.
Thank you.
However, in this case, mother participated in about 50% of the scheduled visitations with the child. The caseworker acknowledged there weren't concerns for mother's appropriateness when she appeared, but it was the concern that she lacked consistency to attend those visits with her child. The second factor is the wishes of the child, in this case through the guardian ad litem due to the age of the child. The GAL testified at the trial and provided in his report that he believed permanent custody to be in the best interest of the child. He testified that there had been 14 months in the case and he saw no progress.
Was there a lack of contact with mother, between mother and GAL?
Yes, Your Honor, but guardian ad litem testified at court that he attempted to contact mother various numbers. I think he specifically acknowledges 2. He says the first number was not active. He then, in attempts, in hopes that she'll show for a June 2018 review hearing, which she doesn't show for. And he received a new number for mother, left a message, and never received a call back from mother. He had received an address for mother, but by July of 2018, she was no longer there and she was homeless. The court actually specifically questioned the guardian ad litem if mother's counsel had provided the GAL with any information as to mother, and he indicated that he did not.
Is it the GAL's responsibility to pursue all those avenues to try to locate mother, or is it mother's responsibility to keep the GAL appraised of contact information?
I believe it's both, Your Honor. I believe the guardian ad litem, if he has information, should reach out to the best of his ability. But when all routes are unsuccessful at that point, there is no other way other than mother reaching out to him.
Well, you said the attorney didn't contact the GAL. Did the GAL contact the attorney?
I don't know if that was questioned, Your Honor. I don't know. The court inquired of the GAL that specific question if mother's counsel provided him the information, but I don't know if the reverse was ever placed on the record.
Okay, thank you.
The third factor in this case is the custodial history. In this case, a voluntary agreement of custody was executed in July of 2017 due to the overdose. The child transitioned straight into the agency's predispositional temporary custody on September 11th, 2017, and remained there for 14 months. This child has been in agency's custody for practically his entire life. The fourth factor is a finding for legally secure placement. The agency in this case investigated multiple relatives, but that went unsuccessful. Maternal aunts, paternal aunt, paternal grandparents. The agency reached out to maternal aunt. The aunts never returned the agency's phone calls. The agency investigated a paternal aunt. However, the family later determined on their own that she was not capable due to her own physical disability. And paternal grandparents ultimately indicated to the social worker that the child would be better where the child was at and that they did not want mother to have contact with the child. Mother argues to this court that she was progressing with her case plan, working towards reunification as she had stable housing and was engaged in drug and mental health treatment. However, that's simply false. At the time of the permanent custody hearing, and as of July of 2018, mother was homeless, going couch to couch in Barberton. Although mother did attend Ohio Guidestone twice for services, she was also discharged twice from services due to noncompliance and missing in excess of 10 sessions. Mother also argues in her brief that she was committed to her case plan. However, in fact, in this case, the social worker testified on cross-examination that she felt that mother was only committed 20 to 25% of the time.
Let me go back to Ohio guidance, that's drug and alcohol treatment.
Yes.
Provided there. You said she was discharged 2 times. Was there a period of time where she was active in her counseling and treatment? In other words, was she there 6 months before she was kicked out, a year before she was kicked out?
Yes, Your Honor. I believe it was 6 to 7 months initially.
Is that in-house residential treatment or non-residential?
That's non-residential, Your Honor. But I wouldn't necessarily agree that there would be any sort of progress. In this case, actually, the supervisor for Ohio Guidestone testified that it did not appear that she had made progress because she was using more frequently towards the end of the case after being involved twice.
Using heroin.
Heroin, methamphetamines, amphetamines, THC, cocaine.
Were those test results in evidence?
Yes, Your Honor. Test results from 7/14/2017, which was actually the day of the voluntary agreement of custody, was just THC. The next one in August of 2017 was just cocaine. But by July 2018, it's amphetamines, methamphetamines, cocaine, opiates, specifically tested positive for heroin and fentanyl. By October of 2018, it's amphetamines, methamphetamines, cocaine, THC, and tramadol. And there's testimony about this. The testimony that the severity and the quantity continued and got more serious as the case went on. More telling in this case was when the supervisor, Mary O'Connell, testified that at the time of the permanent custody hearing, in fact, the case was worse than when the complaint was filed. Mother had lost her housing. The agency assisted in her financially finding. She had no verifiable income. She denied inpatient services for a detox facility and admitted to using heroin on a daily basis. The trial court acknowledged that mother's substance abuse increased in quantity and severity as the case progressed. That she was offered inpatient programming and even transportation to the program, but failed to take advantage of this. Mother also had mental health on her case plan. However, she wasn't engaged. There was testimony that she had concerns with PTSD. This was brought up by mother's counsel on cross-examination multiple times. However, mother missed 2 psychological appointments. So although she was supposed to be engaged with mental health, she clearly wasn't attending.
How many did she attend though?
There was no indication that she attended any. That she had missed 2 psychological appointments, which primarily deals with the medication management side. There's no indication in this case that the trial court lost its way in determining that by clear and convincing evidence, permanent custody is in the best interest of this child. Today, the agency is requesting that this court affirm the trial court's decision in granting permanent custody and terminating parental rights. Thank you.
All right, you have 4 minutes and 49 seconds for rebuttal.
Thank you. It's telling you the GAL, and this is concerning. The trial court should not give much weight or any weight at all to the GAL's opinion in this case, not having ever met with the mom. And I would argue that the GAL has an absolute duty to exhaust all efforts to make contact magnitude. My review of the transcript indicate that really didn't happen. GAL could have went through trial counsel to even establish or schedule a meeting. I've done that in my own practice. But it seems like there wasn't really any type of cooperation between the GAL and the appellant's trial
I guess what I'm
counsel.
looking for is a local rule or statute as to the responsibilities of a GAL and that, along those lines.
My understanding, I don't have a specific rule or statute, Your Honors, but I could say that the GAL has an obligation to get as much information as possible so the trial court can be in a position.
But isn't it also the responsibility of the individual to stay in contact with the GAL, provide that information? That's both ways, I guess.
Absolutely, when the GAL contacts or attempts to contact somebody, it's incumbent upon them to be cooperative, meet with them, provide the information.
I don't want to use up all of your time, but I'm interested in the extent of your client's involvement in dealing with her substance abuse and mental health issues.
She was struggling, Your Honor. She's clearly struggling, and I think, well,
Not the extent of her addiction, the extent of what she did to deal with the addiction.
well, I think her involvement could have been, as far as addressing the problems, could have been better, but she was also in the grips of that problem, which the court's aware that it's difficult when people are struggling with substance abuse issues to make the right decisions. And she was trying to, she did on occasion, she recognized she had a problem, she was willing to engage with services, she had problems and actually following through in this case. This complaint, Your Honors, came on basically on an overdose of father, and the child was removed from the home. Based on that, initially not on the conduct of the appellant. Had the appellant been able to come to that hearing, or had the court continue that, the court could have got a better picture of where she was at in that specific day, which everything else that happened, or up until that point, could have been just water under the bridge, for lack of a better term, had she been able to
So
testify.
I'm struggling with that. What picture would the court have gotten? That she was recovered, was in remission, what? Because the only thing I'm understanding is that the court could have gotten an understanding of just how much she loved her son, which I don't think anyone's disputing.
No, and that's not disputed, Your Honor. I just think that had she been able to appear at the hearing, had she been able to have been composed, had she been able to testify and be of assistance to her counsel, had the trial court been able to observe, see that, hear that, I believe the trial court could have made a different decision in this case. I just think that the fact that not continuing this at least one time, understanding the history, the difficulties that the appellant was having, I don't understand what harm or what prejudice the appellee would have suffered in this case. I mean, all the prejudice and harm was suffered by the appellant. Medina County Department of Child and Family Services, they really don't. Continuance is not going to harm or hurt their interest to continue this thing up to the top of continue. And that's how I would leave it today with this court. I would ask that the court review this decision and reverse the trial court's decision and remand it back for a new hearing on this, so the appellant could actually participate. Thank you, others. Questions? I'm sorry.
All right, thank you for your presentations, both of you. The court will obviously take the matter under advisement, issue a decision in due course. The clerk of courts will mail you a copy of the court's decision on the day it is released, and the opinions are also posted